Hello friends, welcome back to the channel, and I need you to pay very close attention to this one because 4 laws are changing for UK pensioners and the clock is already running. These are not proposals, these are not consultations. These are changes that take effect from August the 1st, and every single one of them will directly impact your money, your rights or your protections in ways that nobody is going to sit you down and explain. I have gone through the legislation, I have read the regulatory guidance, I have checked the implementation dates, and I am going to walk you through all 4 changes right now so that you are not caught off guard, you are not left exposed, and you are not the person who finds out 3 months too late that the rules shifted underneath you while nobody was watching. That is what this channel is for. And that brings me to something I want to say to those of you who are already subscribed. Thank you. You already know that this is how it works. Laws change, regulations update, thresholds move, and when they do, the government does not send a courier to your front door with a summary. They publish a statutory instrument, they update a gov.uk page that nobody reads, and they assume that you, the person whose life it affects, will somehow know. The people who are subscribed to this channel know. The people who are not find out when the bill arrives, when the letter lands, when the right they thought they had no longer exists. If you are watching right now and you are not subscribed, take 1 second and fix that. 1 tap, no cost. And the next time a law changes that touches your pension, your tenancy, your savings, or your safety, you will know about it before it hits. Now there are 4 changes on this list, and I need you to stay until the end, because the 4th one is the single most important legal change for pensioners in years. It affects every single person watching this video, and the window to act on it before the new rules fully apply is narrower than you think. Let us get into it. The first change is your energy bill, and here is what is happening. Ofgem, the energy regulator, adjusts the energy price cap every quarter, and the new cap that takes effect determines the maximum amount your supplier can charge you per unit of gas and electricity. When this cap changes, your bill changes with it, and it does not matter whether you are on a standard variable tariff or a fixed deal that has ended and rolled over, the cap sets the ceiling for what you pay. Here is the problem. Most pensioners are on their supplier's default tariff. They have never switched, they have never compared, they are paying whatever the supplier decides to charge up to the cap, and in many cases that is significantly more than they need to be paying because cheaper fixed deals exist that would lock in a lower rate before the new cap takes effect. The difference between a default tariff and the best available fixed deal can be £100, £200, £300 a year or more. That is real money leaving your account every single quarter because you did not make 1 phone call. The action is this. Before August the 1st, go to Ofgem's price comparison service or a trusted comparison site, enter your postcode and your current usage, and see what deals are available. If a fixed tariff comes in lower than your current rate, switch. You will not lose supply. You will not have an engineer visit. Your gas and electricity do not change. Only the company that bills you changes, and the process takes less than 20 minutes. 1 comparison, 1 switch, hundreds of pounds saved before the new cap bites. The second change is one that could put thousands of pounds back into the pockets of pensioners who have been targeted by scammers, and it is a change that most people still do not know exists. Under new rules that have come into full enforcement, if you are tricked into sending money to a fraudster through a bank transfer, what is officially called an authorized push payment, your bank is now legally required to reimburse you. Not as a gesture of goodwill, not after months of arguments and complaints, as a legal obligation. The reimbursement must happen within 5 business days of your claim, and it covers losses up to £85,000. Before this rule, banks could and routinely did refuse to refund scam victims, particularly older customers, on the grounds that the customer had authorized the payment themselves. You clicked the button, you entered the amount. You confirmed the transfer. In the eyes of the bank, that was your responsibility, even though you were deceived, pressured, manipulated or lied to by a criminal. That is no longer how it works. The law now recognizes that authorization obtained through fraud is not genuine consent, and the burden has shifted from the victim to the bank. If you are a pensioner and you have lost money to a scam in the past 12 months, whether it was a phone call claiming to be from your bank, a text message pretending to be from HMRC, a fake investment, or a romance fraud, and your bank refused to reimburse you or told you it was your fault, that refusal may no longer be lawful. Contact your bank and reopen the claim under the new mandatory reimbursement rules. If they refuse again, escalate it to the Financial Ombudsman Service. The number is 0800 023 4567 and the service is free. Do not accept a refusal that was issued under the old rules when the new rules say otherwise. The third change affects every pensioner who rents their home, and if that is you, or if you have a parent or a family member who rents, this is something you need to understand before August, because the rights you have as a tenant are about to look very different. New provisions under the Renters' Rights Act are coming into force that fundamentally change the relationship between landlords and tenants. The most significant change is the abolition of Section 21 no-fault evictions. Under the old rules, a landlord could give you 2 months' notice to leave your home without giving any reason at all. No fault required, no breach needed. Just a piece of paper telling you to go. For older tenants, particularly pensioners who have lived in a property for years, who have built a life in their community, who rely on local services, local doctors, local support networks, a no-fault eviction was not just disruptive, it was devastating. That power is being removed. From August, a landlord who wants to end your tenancy must provide a legally valid ground. They must prove they need the property back for a specific reason, whether that is selling the property, moving a family member in, or addressing a genuine breach of the tenancy agreement. If they cannot prove the ground, they cannot evict you. This does not mean you can never be asked to leave. It means you can no longer be forced out for no reason. It means you have the right to challenge a notice. It means the burden of proof shifts to the landlord. If you are a pensioner renting your home and you receive any notice to leave from August onwards, do not panic. Do not assume you must go. Contact your local citizens' advice immediately and ask them to check whether the notice is valid under the new rules. One call, one check. And a right that did not exist before could keep you in your home. Now here is the fourth change, the one I told you to stay for, and I want you to hear every word of this because it affects every pensioner in the country, whether you rent or own, whether you have savings or not, whether you are in perfect health or managing a condition, because it concerns what happens to your affairs, your finances, your medical decisions, and your property if there comes a day when you can no longer manage them yourself. The law governing lasting powers of attorney is changing. A lasting power of attorney, an LPA, is a legal document that lets you appoint a trusted person, your spouse, your child, your solicitor, to make decisions on your behalf if you lose the mental capacity to make them yourself. There are two types: a property and financial affairs LPA, which covers your bank accounts, your bills, your house, your investments, and a health and welfare LPA, which covers your medical treatment, your care, and where you live. If you do not have an LPA in place and you lose capacity, your family cannot simply step in and manage your finances. They cannot access your bank account. They cannot sell your home to fund your care. They cannot make decisions about your medical treatment. Instead, they must apply to the Court of Protection, a process that takes months, costs significantly more, and places control in the hands of a court rather than the person you would have chosen. The changes now taking effect modernize the entire LPA system. The new process is simpler, registration is faster, identity verification is strengthened to prevent fraud and abuse, and crucially, the fees have been restructured to make it more accessible, because under the old system, the cost of setting up both types of LPA through a solicitor could run into several £100s, and that price alone stopped thousands of pensioners from ever putting one in place. Here is what I need you to understand. An LPA can only be created while you still have mental capacity. That is the law. You cannot set one up after the fact. You cannot backdate it. If dementia, a stroke, a serious illness, or an accident takes your capacity before you have signed the document, it is too late. There is no workaround, there is no appeal. The window is open now. It will not always be. If you do not have a lasting power of attorney in place, start the process this week. You can do it yourself online at gov.uk for a registration fee of £82 per LPA, or you can instruct a solicitor to guide you through it. If your income is below a certain threshold, you may qualify for a fee remission or exemption, but do it. Do not put it in the pile of things you will get around to. This is the one thing on this list that you cannot fix after the deadline has passed, because the deadline is not a date on a calendar. It is a moment in your life that you will not see coming. So let me bring this all together. 1. The energy price cap is changing, and if you are still on your supplier's default tariff, you should compare and switch before the new cap takes effect, because the savings could be hundreds of pounds a year. 2. If you have been the victim of a bank transfer scam, your bank is now legally required to reimburse you within 5 business days under mandatory reimbursement rules, and if you were refused before, you should reopen your claim now. 3. No-fault evictions are being abolished, and if you are a pensioner who rents, any notice to leave must now be supported by a valid legal ground, so do not accept one without checking it with citizens' advice. And 4. The lasting power of attorney system has been reformed, and if you do not have an LPA in place, you need to act now, because you can only create one while you still have the mental capacity to do so, and once that window closes, it does not reopen. 4 changes, 4 actions, every one of them within your reach if you act before the rules settle and the moment passes. If this video helped you today, I am going to ask you to do 2 things. Subscribe to this channel so that the next time a law changes you hear about it first. And share this video with a pensioner in your life, a parent, an aunt, a neighbour who lives alone, a friend who rents. You do not need to explain everything I have said. Just send them the link. Because one share, one conversation, one moment of making sure someone you care about is not left behind, that could make a real difference. Thank you for watching, friends. I will see you in the next one.